In the term that began Monday, the Supreme Court will hear two cases, one involving a 13-year-old sex offender, the other a 17-year-old probation violator, present when a felony murder occurred, both aiming to challenge life without parole sentences for juveniles. My guest is Stephen Harper. He's an adjunct professor of juvenile justice at the University of Miami School of Law. Stephen, welcome. Thanks for talking with us today.
Thanks for having me.
These are big cases. I want to start with the House Subcommittee on Crime. Apparently, the Crime, Terrorism, and Homeland Security Subcommittee has been, I guess, gathering testimony on a bill that would mandate parole hearings for these types of prisoners at the federal level. Does this have any impact on what the states are doing?
Legally, it has no impact, but I think it begins to show us that there's clearly a change in heart and a rather convincing change of heart throughout the country, that lots of legislatures, including the federal legislature, are also addressing this problem and saying, wait a minute, life without the possibility of parole for kids is too harsh a treatment, and let's rethink this.
Well, it sounds like much of the argument centers around earlier decisions on the death penalty for juveniles, which some argue in this case that a life sentence is a death penalty without an executioner. Is that something you agree with?
Well, essentially, the Supreme Court in a juvenile death penalty case said, in Roper versus Simmons says, kids are different. And they have special developmental characteristics. They have diminished culpability. They're immature. Their judgment is immature. And they also have a capacity for change and rehabilitation. And what the people are saying here is that if you look at what the Supreme Court has already said about kids, then if you look at the fact that those same kids are going to die in prison without any chance of parole, that is almost as bad as the death penalty.
Talk about these two cases individually. And it looks like the Supreme Court is going to be hearing both cases separately based on their age, one at 13 and one at 16 at the time of the sentencing.
It's hard to tell. One never knows why the court does what it does. But on the one hand, one is a 13-year-old kid. There are only two 13-year-old kids serving life without the possibility of parole for non-homicides in the entire country. 16, 17 more kids are on the serving life without the possibility of parole. And one is not sure whether the court wanted to draw a line between, let's say, a 13-year-old and a 15-year-old or a 16-year-old, or, and this is another possibility, the first case that went up, actually the kid, there may be some procedural issues in play, and so they may have taken the second case in order to not have to deal with those procedural issues. In other words, the first case, the 13-year-old, there may be some issues that the court would say, wait a minute, this is not right, this should not be before us, and so they took the other case in order to deal with the issue one way or the other. It's not clear.
Joe Sullivan is the 13-year-old, Terrence Graham the 16-year-old. Could it be possible that the court just sees that there is a difference between a 13-year-old and a 16-year-old, just inherently?
That could be it, and I think that remains to be seen what the court's going to do with this, but clearly 13-year-olds are very immature. They don't have anything like the capabilities of an adult. And if you have a 13-year-old, and I don't know if any of us remember being 13 or remember our 13-year-olds, that is one of the most difficult ages, and it's really hard to say that a 13-year-old deserves life without the possibility of parole, period, end of story, end of sentence. We're never going to consider this again. Now, the same thing, though, applies to 17-year-olds and 16-year-olds. While they may not be as less culpable, or they may be more culpable in the sense that they're older, they're wiser, they have more control over their emotions, and so on. Nevertheless, I think 16 and 17-year-olds are clearly less culpable than grown-ups. And really the issue here is going to come down to whether the court's reasoning in Roper versus Simmons, that kids are simply different, goes over into the non-homicide world.
It seems logical that a lot of the science would indicate that kids are definitely different than adults, both from a developmental standpoint, both mentally, physically, maturity-wise?
That's right, and it's interesting that the American Psychological Association has filed a brief along with the American Psychiatric Association mapping out the many, many ways in which kids are very, very different than adults. They don't have the same sense of consequence. They don't have the same ability to control their impulses. They don't have the same ability to understand long-range consequences. And that's not to say they don't know right from wrong. They do. And nobody's saying, by the way, that these kids should not be punished. Mm-hmm. All they are really saying is, well, give them an opportunity because of their youth to have some form of review at some point to possibly be released. And the American Medical Association, while they did not take a specific view one way or the other, also put a brief into the court saying, look, kids are different not just because of their behavior, but also because their brains are different.
Do you think there's something during sentencing that perhaps a judge would hand down a stiff penalty like this because he might down deep think that if a child commits a crime like this, they're inherently bad to begin with?
I think that is a normal reaction, mm-hmm. and I think that in a get-tough world where you're dealing with a here and now and you're dealing with a terrible crime, that's the easiest thing for a judge to do, which is just to say, this is a bad seed and the end of it. Mm-hmm. Fortunately, or unfortunately, depending on one's point of view, the science is on the kids' side.
Right.
Most of these kids grow up, they grow older, they grow more mature, they get a much better sense of who they are, what they've done. And most kids, not all kids, but most kids will not do this kind of thing again. And what's interesting about this case is that while there's a lot of back and forth between what law should apply, kids are bad, kids are not bad, all they're really asking for is an opportunity to have somebody, again, someday consider the fact that this kid may actually be okay and be worthy of a release 40 years from now, for example, 50 years from now, but have some opportunity to have his story told and to have somebody, usually a parole board, reevaluate who this person is.
The complexion of the court has changed with Sonia Sotomayor joining the bench beginning Monday. Do you think still this kind of a case, the decision will come down to Justice Kennedy again?
I do. I think that it's unknown where all the people in the court stand on this particular issue. So it's a bit of a crapshoot. There isn't the same sort of, we know where these justices are, we know where these justices are. But I would think, based on other cases and other court cases, that it's going to come down to Justice Kennedy. And what's interesting about Justice Kennedy is he wrote the opinion in Roper versus Simmons. He also wrote the concurring and controlling opinion in a case called Harmland versus Michigan, which deals with life without the possibility of parole for non-homicide offenses, and talks about how the Eighth Amendment proportionality principle applies to non-capital cases, but in an opinion which had different reasons for, it's called a plurality opinion. In other words, mm-hmm. different people wrote different reasons for agreeing on the final result. But Kennedy, in that case, defers to state legislatures a great deal because it's a non-death case. So it's going to be interesting to see where Justice Kennedy comes down on this issue. And it's an issue the court has never specifically addressed before.
Is there something inherent in the Sullivan-Graham cases that make these cases or give these cases a good shot? As opposed to the other cases, there's 2,500 juveniles in prison with a life sentence. Oddly enough, a lot of them are in Florida.
Florida's a tough state, and just that part of why this happened in Florida is because the juvenile system only punishes up to age 21. Mm-hmm. So whether you're rehabilitated or not rehabilitated, when you turn 21, you're out. And a lot of people had trouble with that. And with the crime increasing in the early 90s, juvenile crime in particular, they started to send more kids into the adult system. It was a very rapid sending kids into the adult system, while at the same time, the adult system was getting tougher. But that was not an intentional thing. In other words, they were both happening at the same time, but not in coordination with each other. So in Florida, we ended up with this, wait a minute, 13-year-olds can go to prison for the rest of their life, and that is the situation. But to answer your question, I think that in Florida, as in other states, their court is actually saying, wait a minute, there's something wrong with a 13-year-old, there's something possibly wrong with a 16-year-old or a 17-year-old. Let's take a good look at this case.
Mm-hmm. Stephen, we appreciate your time. It's been a great pleasure talking to you.
Pleasure talking with you. Thank you.
My guest is Stephen Harper. He's an adjunct professor of juvenile justice at the University Miami School of Law. This is Scott Drake, and you're watching the Legal Broadcast Network.